أعوذ بالله من الشيطان الرجيم. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum and a very warm welcome to this edition of On the Couch here on Radio 786 on 100.4 FM. My name is Zainab Bean. Now this week we are back in studio for our Advice Assembly series with housing activist NGO Ndifuna Ukwazi. On the 26th of June, the City of Cape Town published its Draft Unlawful Occupation By-law for public comment. The controversial draft bylaw seeks to standardize the city's response to all the existing and intended occupations on any land or building. The draft bylaw therefore has the potential to affect hundreds, if not thousands, of poor and marginalized people in our city. For this and other reasons, Ndifuna Ukwazi has taken issue with the draft bylaw that is out for public comment until 31st of July. Ntombi Sambi, political organizer from Ndifuna Ukwazi, and Daniel Lowe, attorney from Ndifuna Ukwazi, are back with us today to discuss what the bylaw says, why it's concerning, and how you can make your voice heard. Let's welcome both. Good day and thanks so much for your time, both to Danny and also to Ntombi.
Thank you very much for having us.
Absolute pleasure. I hope that you're keeping warm and keeping safe. It's quite cold here in Cape Town, very cold in Cape Town. Let's start with Danny. Danny, what exactly is the draft bylaw and what does it say?
Thanks, Zainab. So the Draft Unlawful Occupation By-law is a bylaw that the city created in terms of its competency that comes from the Constitution to create bylaws that relate to certain administrative matters that the City of Cape Town as a local government has. So the city intends to use the Draft Unlawful Occupation By-law to prevent the unlawful occupation of not only land and buildings owned by the city, but also those that are privately owned. So this bylaw comes in the wake of the city's Draft Unlawful Occupation Framework, which provides that the city should proactively plan for informality and establish mechanisms to preemptively protect public land from unlawful occupation. But what we've seen is that this draft bylaw goes far beyond just preemptively protecting the city's land. So what we've seen is that this bylaw seeks to criminalize the unlawful occupation of land. So it does this by creating several offenses that carry the sanctions of a fine or imprisonment of between 6 months and up to 2 years. The bylaw also grants authorized officials, who it doesn't clearly define, the power to arrest occupiers without a warrant, impound their belongings, and search them, and also then identify and monitor certain buildings and land that may be prone to unlawful occupation. So as we can see, there's wide-ranging powers that the bylaw intends to confer onto its authorized officials. Yet despite giving these powers, the draft bylaw doesn't provide clear guidelines on how these powers should appropriately be exercised. It also, concerningly, lacks any accountability mechanisms to guard against the abuse of power by officials. And as you mentioned, Zainab, we are very concerned that this draft bylaw will affect thousands of poor and mainly Black people negatively.
Now, Ntombi also joins us on the line this evening, and of course, Ntombi Sambu is a political organizer from Ndifuna Ukwazi. Ntombi, how did this bylaw come about?
So it's also important that we don't think about this bylaw on its own, but keep in mind that it is published in a context of rampant spatial inequality, a massive shortage of well-located affordable housing, and amid fierce criticism of the deplorable conduct of the city's anti-land invasion unit and law enforcement officers during unlawful evictions. As some of your listeners might recall, last year, in direct violation of the law and a nationwide ban on evictions, the city's law enforcement officers, who had been sent to demolish people's homes in eThekwini, dragged Bulelani Golane from his home while he was bathing. We also have been made aware through media reports of the recent evictions that took place in Fulani. Here again, a community member was evicted while she was bathing. and spend the night in jail without her clothes. The city's dehumanizing, humiliating, and unlawful conduct during these evictions show how evictions often take place across the city and has caused outrage at the city's frequently violent and arbitrary evictions of people living in informal settlements. We also see this move by the city as a way of circumventing the interdict obtained by the South African Human Rights Commission, which came as a result of this conduct.
Now, Danny, are you saying that the city of Cape Town has not taken the massive inequality and housing shortage into account when they drafted this bylaw?
So it certainly doesn't appear so. As we know, the causes of occupations are multiple and nuanced, but treating occupiers as criminals fails to recognize that the vast majority of people are forced to occupy land out of need. Generations of dispossession, an inability to develop a coordinated response to rapid urbanization, and also just a systemic failure on the part of our government to deliver on the promise of a functioning state-subsidized housing program have all contributed to this crisis. So it is this context that is exactly why unlawful occupiers were granted legal protection in our Constitution, and why also in 1996 we had the decriminalization of occupation. But now this draft bylaw seeks to undo these constitutional gains that we've obtained. We also have to remember that the urban informality that we are seeing is driven by historical, racial, and class exclusion. It is this exclusion that has defined the urban policies and priorities of development in the city of Cape Town for decades. Now, with the current COVID-19 pandemic that we are still grappling with, this has essentially laid bare the deeply entrenched inequitable access to housing and land in our country. And tenure insecurity, which is people's security and their right to their home, has become a definitive effect of the impact of the pandemic. So we are concerned that this draft bylaw reflects an approach to informality that echoes the apartheid government's displacement and forced removal of Black and colored people from urban centers. In addition to anti-poor measures, the draft bylaw also has the potential of creating a police state through the arbitrary exercise of power by law enforcement agencies and its undefined authorized officials. The city's excessive use of force during unlawful mass evictions, as Ntombi just highlighted, during the early months of the lockdown, and then also the city's defense of these actions, has highlighted the urgent need for policies that curb the power of officials. But what we are seeing is that rather than protecting the communities to whom the city owes an obligation to, the draft bylaw does little to curb the power of officials, but instead gives it more power.
You are listening to Radio 786 on 100.4 FM. If you have just joined us, this is On the Couch. And of course, this week we are back in studio for our Advice Assembly series with housing activist NGO Ndifuna Ukwazi. Now, we are talking about the draft bylaw that seeks to standardize the city's response to already existing and intended occupation on any land or building. Now, this draft bylaw therefore has the potential to affect hundreds, if not thousands, of poor and marginalized people in our city. Now, to tell us a bit more about this and to give us just an update of what it is that this draft bylaw is saying, we are speaking to Ntombi Sambo, who is a political organizer from Ndifuna Ukwazi, as well as Ndifuna Ukwazi's Danny Lowe, who is an attorney from Ndifuna Ukwazi. Now, Ntombi, all of the things that was just mentioned by Danny does really sound indeed concerning. Besides criminalizing occupiers, are there any other sections in the bylaw that are of interest? You mentioned that the bylaw also affects private landowners. Tell us about this.
So then, yes, there are many problematic provisions. As mentioned, the city wants to prevent unlawful occupation on city and privately owned land, which is land for purposes of the bylaw refers to land and buildings or a portion of the land or a building. The draft bylaw therefore wants to compel private owners to prevent unlawful occupation. It says that should a private owner not comply with a notification by the city to take steps to prevent an unlawful occupation of their land, that the city can, with the consent of the owner, take necessary measures on the owner's behalf and at the owner's expense. If the owner does not give their consent, the city can approach court for an order that would allow it to take the necessary measures on the owner's behalf. The city also wants to identify and monitor land and buildings that could be occupied. This means that the city will deploy its officials to patrol and protect these sites. We are concerned that this may mean that there will be a heavy law enforcement presence in certain areas, especially if those sites are located near areas where poor communities live. Further, to prevent an intended occupation, the draft bylaw wants to give the city the power to close roads surrounding the land intended to be, or that is being unlawfully occupied, in order to prevent vehicles transporting people carrying their possessions or building materials from entering the area. It says that the city must then immediately give notices to people not to enter the land, or if they have entered the land, to dismantle structures and leave the area with their building materials and possessions. As mentioned earlier, the city wants to criminalize occupation, including preparing to occupy. It means it's a crime to occupy land, but also to instigate or organize an unlawful occupation, to clear the land with the intention to occupying it, like removing vegetation or other means to remove or damage any signage indicating that the land cannot be occupied, to solicit payment for arranging or organizing a person to occupy land without the consent of the owner, to sell or purport to sell structures on land that is or is intended to be invaded, and to transport people or building materials and personal possessions to the purpose of an unlawful occupation. As we can see, the offenses implicate all the people who might be involved in an unlawful occupation and imposes prison sentences of between 6 months and 2 years, or a fine, or both, a fine and imprisonment.
Danny, listening to what you are saying, I must ask, is the bylaw compliant with the law?
So that's a very good question, Zainab. The city also wants to use this bylaw to search people, to search their vehicles and their structures, all without a warrant. It then also says that the officials may seize or take anything found as a result of their searches. So we are very concerned that people's right to privacy may be affected, as this power that they are intending to confer onto their officials is not in accordance with our national law. This is because our national law says that it is only peace officers who, like the police, and not a municipal police service, like the city of Cape Town intends to mandate with these powers, who may search a person after they have arrested them. So this is very concerning, because we're seeing here that the city is going against the national law, which is the Criminal Procedure Act, which confers the power of arrest only onto peace officers like the police. This also leads us to another problem with the draft bylaw. The bylaw wants to give the city's officials the power to arrest occupiers and then also dismantle and impound their building materials and property. Here again, we are also concerned that the city is giving its municipal police the power to arrest. And this power is invalid, as it is only peace officers again that can arrest, such as the police. We also know that the city wants to give the municipal police the power to we are concerned that this might impact and infringe on the rights of people's right to property, as well as their right to access housing, specifically in the event that these officials might impound people's building materials.
Ntombi, does the bylaw provide guidelines to city officials on how to exercise their powers?
So the city also wants to decide whether occupations can get emergency or interim basic services, and then relocate those unlawful occupiers to whom it cannot offer these services. There are no guiding principles provided that would inform this decision, and we are concerned that this would allow potential arbitrary decision-making in respect of which informal settlement will get basic services. So it also wants to give itself the power to decide whether a structure constitutes a home. This is very concerning, as the draft bylaw does not tell us how the city will determine whether a structure constitutes someone's home or not. What informs their decision at home looks different to different people, and we don't believe that the city is equipped to make such a determination. I mean, we all know that the city of Cape Town, it doesn't see people's shacks as home. We might call it our homes, but then to them, it's totally different. The draft bylaw also pays that the city can then also resettle people who they have prevented from occupying or who have been evicted in terms of PI after occupying. The bylaw says that the city may resettle people in terms of its own managed settlement program, which is concerningly not a program that exists in terms of national policy. The bylaw, however, says that it is only if there is a place available and it's managed settlement program that occupiers may be offered a place. It does not say that will happen to people forced to resettle in the event that there is no place in its managed settlement program. So which means if the people are removed and there is no place, then that's it for the people. People will be homeless. So it doesn't actually say that when they move people, then they'll be potentially like moved to a certain areas and have like a place there. So it's honestly problematic at the moment.
Of course. Danny, I do hear your concerns, but people might also argue that the city can't just allow occupation wherever, anywhere, especially if it could disrupt necessary projects that are underway. So what would you say the city should be doing instead?
Yeah, so as the city's draft unlawful occupation framework says, this is the framework that we also referred to earlier, the city needs to proactively plan for informality, which also, if we take into account the current socioeconomic situation in our country, is only set to get worse. The city should know that this blunt instrument of evictions is not a considered response which will sustainably address the reality of land occupation that, like we've said, is driven by the continued state of tenure insecurity that people face. There have been a few targeted legislated means of addressing informal settlements, which emphasize the recognition of the urban poor instead of their repression. So one of these is the upgrading of informal settlements program, or the UISP. But what we've seen is that such mechanisms remain underutilized in comparison to the state's reliance on evictions. We are concerned that the city will continue this trend by choosing to adopt procedures that fall outside the ambit of international human rights norms, national policies, and provincial guidelines. And as you've said, Zainab, we of course recognize the need to protect both public and private land, particularly land that has been identified for the provision of social amenities and services. Yet the proactive protection of land should not perpetuate dispossession and compound people's vulnerability. As mentioned, the city needs to proactively prioritize and plan for informality and urbanization through the provision provisions in the Constitution that says that the city needs to increase equitable access to land and access to adequate housing, especially considering that we are sitting with a backlog of about 365,000 families that are in need of homes here in the city of Cape Town.
Absolutely. Now, Ntombi, how exactly can people make their voices heard?
The draft bylaw is open for public comment until 31st July, which is next week, Saturday. So we're also concerned that the time and manner of the city's call for public participation does not offer those who would be most affected by the draft bylaw a meaningful opportunity to engage with this content. So this does not give people enough time, especially now that we're on level 4. People can't meet. So they can't discuss this issue about the draft bylaw, especially people who don't know about it. So, Zainab, for us, this bypasses the fundamental principles for consultation, people-centeredness, and the true community participation that our Constitution calls for. We are therefore call on everyone affected by this law to make their voices heard on to the city. Whether you're an occupier, an intending occupier, or a private owner, you are affected. You can contact Deputy Chief of Law Enforcement Leon Wenzel on 021 444 0231 or email him at unlawful.occupation@capetown.gov.za. If you need help submitting your comment, you can contact Anati Gwili at 021 400 9825 or email her at anati.gwili@capetown.gov.za. Once your comment is ready, you can submit it online on the city's website, hand deliver it to your nearest sub-council office, or post it to Leon Wenzel, Law Enforcement Department, first floor, Omniforum Building, at 94 Van Riebeeck Street in Gills River.
I think that is it for us. Is there anything else, Danny, that you'd like to add? Maybe why people should make their voices heard, Danny?
I think just to emphasize Ntombi's last point on the need for participation in this process. So as we've said, it is occupiers, people living in informal settlements, and also private landowners that are to be affected if this draft bylaw gets passed. Specifically because the city can force the private owner to comply with a notice by the city that the private owner should protect its land from unlawful occupation. And if the private owner doesn't do that, the city may approach court and then in that way force the private owner to incur expenses to protect its land. So we really want people from in different positions and in different capacities to make their voices heard, to tell the city how it will affect them. Because as Ntombi was saying, we do live in a participatory democracy, and it's important for us to participate in decisions that affect us.
Absolutely. Remember that the draft bylaw is open for public comment until 31st of July, which is next week, Saturday. And therefore, there's a call on everyone affected by this bylaw to make their voices heard to the city. Whether you're an occupier, an intending occupier, or a private owner, you are affected. You can contact Deputy Chief of Law Enforcement Leon Wenzel at 021 444 0231, or you may email him at unlawful.occupation@capetown.gov.za. And if you need help submitting your comment, you can also contact Anati Dwili at 021 400 9825, or simply email her at anati.dwili@capetown.gov.za. capetown.gov.za. And once your comment is ready, you can submit it online onto the city's website, hand deliver it to your nearest sub-council office, or post it to Leon Wenzel, Law Enforcement Department, first floor, Omniforum Building, 94 Van Diebeek Street in Kuils River. And that is how we come to the end of another Advice Assembly with Ndifuna Okwazi. We say many thanks to both our guests, which of course is Tombi and Danny, speaking to us this evening about the specific bylaw. So we spoke to Tombi Sambo, who is a political organizer from Ndifuna Okwazi, and of course Daniel Lowe, attorney from Ndifuna Okwazi. Thanks so much, and until we are in each other's company again, bye-bye.
Thank you very much. Bye.
Okay, bye-bye. And that, of course, is our Advice Assembly for tonight. From myself, Zainab Bin, until the next time, I bid you assalamu alaikum wa rahmatullahi.